I'm going to really focus today on what the law is. And really, I think what has been really important, and I think you heard it from Judge Rucker and both Jonathan and Lynn, is that really our law as it exists right now is really top notch. And that's because, frankly, we are the best state in the union. Thank you very much. Woohoo! And also, I wasn't born here, but I got here as fast as I could. I was born in D.C., so I think that still counts as really that I get to be like loyal to Texas, right? So anyway, we are truly the best state, and we have legislators who have worked really hard at having and getting the law that we have. So I think it's great that we preserve the law, because really the law as it exists allows us to do the best that we can with regard to children and when parents have the children. So with that in mind, here's my email if you want to write that down. If you have any questions at all, feel free to email me. And it's in your packet, I think. So there's your email. If you have any questions whatsoever, give me a shout. I'll be more than happy to answer any questions that you have. You know, divorce lawyers, we all have really bizarre senses of humor. It's just one of the things that we have to deal with on a daily basis. Really, there's two critical things that the Family Code really tries to achieve. First, we want good parents, and I say good because there are parts of the Family Code where we are really trying to protect children from bad parents, and there is such a thing as bad parents. But we want good parents to spend time with their children as much as possible. And then also, we also have a need, and one of the big parts of the Family Code too, is for parents to support the children that they create, obviously. That's a foreign concept to some people. Some people don't understand that they're supposed to create or support the children that they actually have. Now, obviously, the overriding factor in the Family Code is that we always consider what's in the children's best interest. It's in every case that we have that we go in front of any court for, the overriding thing that we're considering is what's in the children's best interest. And that's supposed to be the primary consideration, whether we're talking about conservatorship or possession of and access to the children. And really, we're even going to think about best interest of the children oftentimes in child support purposes too. Judge Rucker talked to you guys about public policy already, and so I don't want to go over that too much, but let's just suffice it to say that, you know, the public policy of the state is that parents have frequent and continuing contact with their children. We want children and parents to be and have a lot of time together. That's going to be in their children's best interest. We want to optimize the development of a close and continuing relationship between each parent and children, and that includes frequent contact between each child and each parent. Now, Judge Rucker talked to you about about conservatorship, and really, truly, this is interesting because we're going to assume when we're talking about most things anymore, people are presumptively joint managing conservators. There are no longer do we have these as much. We don't have possessory conservators and sole managing conservators, because those are custody issues that are reserved mainly for people who are going to have like horrific drug or alcohol issues. So really, most oftentimes, if you've got good parents, people walk into the courtroom anymore these days being joint managing conservators, meaning that they share equal rights and duties. So really, the old version, the olden days, like old, I mean early 90s, of one parent being a sole managing conservator where they had all the rights and duties, that's out. It's been gone for a long time, and people walk into the courtroom being joint managing conservators. And that's what the legislature said that they wanted back in the 90s, and that's where we are. So nowadays, when we're talking about the standard possession order, which I'm going to show you what that is specifically in just a few minutes, the Family Code says that the standard possession order is supposed to be a minimum possession order for joint managing conservators. A lot of people don't understand that. We're not supposed to, when we need to limit possession, when you have a parent that's really not a super parent and maybe they've got a drug or alcohol problem, then when we limit a parent's possession, the Family Code further states that we're only supposed to limit it only to that point, only to that portion that requires us to protect the child. So we don't want to go overboard in limiting either a bad parent's contact with the child. A child may, so reading this, really, we should only do it to the point such that that visitation or that possession, rather, is not going to exceed that which is required to protect the child's best interest. So, Judge, you talked about some things that the court usually considers factors for possession. Are there kind of taking out just legal issues, are there any other things specifically that you consider when you're trying to decide what sort of possession order you might give somebody?
Well, of course, we always start with the standard possession order. Yes, I will. That's where we start, is with the standard possession order. And I will tell you, all judges are different. I mean, some judges stop and start there with the standard possession order, and others use that as a building block on which they can create additional time for parents who've shown the ability to communicate and to interact with one another, and for a child to do well. So usually that's what the judge is looking for. Are we going to optimize good quality time for a child with a parent when we go beyond the standard possession order? So.
Well, and in fact, the Family Code also provides in this section right here that if we can't go by the standard possession order for some reason, that we're supposed to follow a possession order that is as close to the standard possession order as possible. Okay, children under 3, I'm not going to spend a lot of time on that because we are a little bit pressed for time. So just know that there's some very specific factors. I set them out for you in your packet. So when there's factors for children under 3, they're set forth for you in your packet. There's very specific provisions in the code and a section in the code as to those sorts of factors that we should be considering. And I think that John did a very great job in talking about some of those things. Obviously, you've got some breastfeeding issues. You may have the temperament of a child. You may need to know, how close in proximity are the parents when you're talking about factors for a child under 3 and those other things that are in your packet. I want to go over with you, though, one thing that we usually do a lot of times when we have a child under 3, we'll do more frequent contact as opposed to lots of contact all at once. So we might do several times during a week. We might do maybe a Tuesday and a Thursday evening, and then maybe we'll do a first, third, and fifth weekend, because that's kind of a key language as you're about to see. And maybe we'll do a Saturday and a Sunday for several blocks of time, maybe 2 or 3 hours on Saturdays and Sundays, depending upon the age of the child. First, third, and fifth weekends are really key, and you're going to see that in just a second. We determine first, third, and fifth weekends by the first Friday of each month. It's not the first Saturday, it's the first Friday. So when you're looking at this, you'll look at October, and actually October starts on the first day of the month. Saturday was actually the first, and you might think that that's the first weekend, and it's not. That actually, it's highlighted because it's the fifth weekend. It's the carryover because the 30th of September, or I guess it was 30th of September, was actually a Friday, which made it a fifth weekend in September. So the first was it's highlighted because it's part of a fifth weekend, but the first weekend in October is actually the 7th because that's the first Friday in October. So you got to count Fridays when you're looking at first, third, and fifth Fridays. You got to go by the first Friday of each month. Our standard possession order, if you highlight the days, looks much like this. Under a standard possession order, and this is just a regular standard possession order, it looks like this, and you'll see that the parent who is not the primary parent, because you have the primary parent is what I call them, that's the person who has the right to establish the primary residence of the children. It's really the parent who has the exclusive right to establish the primary residence of the child or children. The person who is not the primary, under the standard possession order, just regular standard, has possession of the children for 156 days under this regular standard possession order. Now, let's really kind of take a look at that and see what that is. The standard possession order, just the regular standard possession order, is the first, third, and fifth weekends from 6 on Friday to 6 on Sunday. Now, if your parents were divorced or if you were divorced, then you may know this, but there are people out there who don't know this. And so this is the actual standard possession order that everybody is talking about right now as exists currently in our law in Texas. The standard possession order includes Thursdays during the school year, not during the summer months, but during the school year, from 6 to 8 on Thursdays. The parent who's not the primary gets 30 days in the summertime of their choice. They can break that up into 2 separate periods, or they can take one 30-day chunk of time. And if they don't designate by a certain date, then their default is July. The parent gets either Father's Day or Mother's Day, depending upon their gender. And no, I don't want to discuss transgender issues right now and which they have to elect, because I'm not going there just yet. Our code doesn't discuss that yet, and maybe someday we'll do that, but we're not going there now. And then we alternate Thanksgiving every other year, and then we also we split up the Christmas holiday, depending upon whoever got Thanksgiving. So whoever got Thanksgiving then doesn't get the children until the second half of the Christmas break, and that second half of the Christmas break, the children are just exchanged on the 28th of December at noon. Now, if you do the math under the standard possession order for this year, this calendar year, it's 43%. Now, this is just the standard possession order, okay? Now, we also have the standard possession order with the overnight election. The election is the father's election. So, the standard possession order with the election provides 23 more days than the regular election. It is totally the non-primary parent's election, meaning they can decide if they want to do it or not. It can be combined. And what the election really is they get first, third, and fifth Fridays at the time school gets out until the time school resumes on Monday morning. They get Thursdays during the school year at the time school gets out on Thursdays until the time that school resumes on Friday mornings. They get 30 days in the summer, just like the other standard possession order. They get either Father's Day or Mother's Day. They get alternate Thanksgivings and Christmas, just like the other standard possession order. But how does that shake out? That shakes out to, if you'll see at the bottom of that last slide, that's 179 days. And so, if you do the math on 179 days that they actually have their children, that's 49%. So in 2013, that's 49%. They see their children on those days with the election. Now, that's 3.5 days difference. And I just have to tell you, so people come in and they see me, and they come and they're like, blah, 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 I want to fight for custody, I want to fight for custody. And so I'm like, okay, well, pony it up and get your checkbooks out so you can write me a retainer, of $10,000. So you really want to spend $10,000 over 3.5 days? That's fine. I'll take your money. Let's go pony it up. But, just know it's going to be long, it's going to be expensive, and it could be well more than 10. It's probably going to be well more than 10. So just let's go. But it's their choice, right? That's how I make a living. Really, these numbers, I want you to know, these numbers do vary according to how the calendar falls. And as I was preparing for this, I will tell you that in 2014, when I did this slideshow originally, was it 14 or 15? I don't recall. The numbers were not quite what they are now. When I did it originally, the percentage was 47% and not 49%, okay? So just want you to know, depending upon how the calendar year falls. But I want you to look at this, because we're not done with what our standard possession order does with the overnight election for people in this state. So understand what we have and how much people get to see their children. I call it eyeball to eyeball time. I do that with my clients. Eyeball to eyeball time with your kids. So we have 179 days, but you get to add on some. Why? Because on my little highlighted calendar that we saw up there a little bit ago, I don't highlight those Fridays when they get to take their children to school. Now, I highlight the Fridays that are their Fridays because it's the first, third, or fifth, but I don't highlight those Fridays on Thursdays where they take their child, they get Thursdays overnight to Friday morning when school resumes. I don't highlight those Friday mornings when it's not their Fridays, right? So, but they get to spend Friday morning taking their child to school, having breakfast with them, dressing them. So I highlight those Fridays. If you talk about Fridays, they get to add those Fridays. Usually they're going to get either Memorial Day or Labor Day, one of those days, so you can add that on. Somewhere in there, usually there's some school holiday that they may or may not get in there. But usually also think about this. If they don't otherwise have possession of their child on their child's birthday, and that's just one child, if they have more than one child, they could get more days here. but they at least have one child or we wouldn't even be here. You get to at least add 1 day, potentially. And so potentially they could even have as many as 200 days of eyeball to eyeball contact with their child under our current standard possession order with the overnight election that our legislators came up with and that exists currently. I think it's a pretty awesome plan myself. So the big secret is, last I checked, 182.5 is obviously 365 days out of the year. So 182, divide it in half, right? So obviously 200 is more than half of the days of the year. So people are seeing their children eyeball to eyeball time more than half of the days of the year under the standard possession order. So it's kind of, to me, a no-brainer that this is a great plan. If you're going to be divorced, okay, great. You may not be able to see your child every single day, but you're going to see your child 200 days out of 182.5 days of the year, or out of 200 out of 365 days of the year. You know what? That's really not so bad. So what's the big elephant in the room? Really? What's the big elephant in the room? And every family lawyer knows this, and Judge Rucker over here is like nodding his head right now. So what's the big elephant in the room? Why is there all these people always complaining about the standard possession order? Oh my God, I'll never get to see my kid. Right? Because they always whine and complain. Trust me, because we see that as family lawyers and judges. That's what we hear. They think if they have 50-50 time, they don't have to pay child support. That's what they all think. Well, guess what? The law doesn't say that. And so when they think that, then as a family lawyer, I just have to tell them, well, you're wrong. And maybe in California, where Brad, Jelena are, Angelina and Brad are, because I've read all these articles and, oh, it's 50-50 out there, or you don't have to pay child support when it's 50-50. Well, maybe that's California, but that's not Texas. Because in Texas, what the law says here, basically, is that the court may order either or both parents to support a child in the manner specified by the order until, basically, the law is in Texas. Somebody's going to need to pay child support till a child's 18 or when they graduate from high school, whichever is later. Also, if they become emancipated, then that obligation goes away, and emancipated would be maybe they get married early, if they join the armed forces before they turn 18, right? That emancipates them. Or if a child dies, or sometimes child support can be paid or order paid indefinitely if the child is disabled. The courts still look at and will consider things when it comes to child support, such as the ages and needs of the children, the ability of the parents to contribute to the support of their children, any financial resources available for the support of the children, the amount of time of possession of and access to the children. And obviously that last one on this slide is a pretty key factor here, because the courts can consider that. So the court can consider all of those things. And the Family Code also talks about the support guidelines are just that. They're just guidelines to determine an equitable amount of child support to be paid. And the courts will also look at the obligee. The obligee is the person who receives the child support. The obligor is the person who pays it. The person who receives the child support, the court can look at that person's net resources, including potential earning potential, daycare expenses, any auto or housing or any other benefits furnished by an employer. The courts can look at the cost of travel to exercise possession, any extraordinary health or educational expenses, any expenses for a son or daughter beyond secondary school, and provisions for health care insurance, which, God knows that's expensive these days. Also, the courts can consider any cash flow problems or debts or debt service assumed by either party and any other reason consistent with, here we go again, here's that best interest of the children, taking into consideration the circumstances of the children, of the parents rather. So the court can look at all these factors when trying to decide, okay, child support, anybody get to pay it? Is anybody going to pay it? So if there is some sort of deviation from the standard possession order, the courts can decide to deviate from the standard support guidelines. So Judge, are there any things that you look at specifically when you're trying to just say, child support when deviating from a standard possession order?
Sure. When we talk about the parents who agree to the 50-50 possession, as Cindy told you, a lot of parents don't think about that child support issue, and they agree neither party's going to have to pay because each of us is going to have the child half the time. But what they're overlooking is not everybody's coming into that type of thing on an equal plane. Somebody is a lower compensated spouse, and they're going to have a hard time when they have the child 50% if they're having to rely solely on their own income to provide for the child, meet the child's needs, enjoy some of the things, while maybe the highly compensated spouse who has the child the other half of the time is able to take the child to Disneyland and lots of other things. I have often mentioned from the bench, before you all finalize your agreement, think about the effect of no child support being paid by either party and what that's going to mean for the quality of the time that the child is going to have with each of those parents. And sometimes they come back with a child support figure. When courts have had to decide that, they have simply, they have a lot of different remedies. No statute tells us exactly how to do this. When we have kids who are spending half their time in one place and half the time the other. But they'll often figure out what the child support would be under the guidelines for each parent. Let's say they have one child. So if mom had the child and had to pay child support to dad for one child, it'd be so much. If dad had to pay child support to mom for that one child, it'd be so much. And offset the two and require some amount of child support to be paid to the lesser earning spouse. That's one remedy. So the factors that Cindy has given are all good. I will tell you that most cases are resolved by a resort, just an absolute resort to the guidelines, the way it says. It's you figure out what somebody's net resources are, and you figure out the percentage depending on the number of children, from 20% to 35% of net resources. And when you go beyond that, then you need to start talking about the actual expenses that it takes for a child, for example, to go to private school, to have a private education, to meet some special needs for the child. All of those factors are there. And these factors allow the courts to deviate from a strict application of the child support guidelines.
I think the thing to take away that I want you to know is that I believe our current law provides us the best, absolute the best system in the United States. And it allows judges to decide each case on a case-by-case decision. And if the judges decide they want to do something different than what the standard possession order provides, because perhaps people have different jobs that don't follow the standard possession order, then the courts certainly have it in their power to do so. And our law currently allows the judges to consider lots of different factors, as you've seen, and gives the judge the opportunity to do so. And currently, too, our law with regard to child support allows the judges to consider many different things when setting child support as well. So I believe, and I'm going to encourage you guys to also look at the law and see what it is, and know that our current law, as it exists, affords us a great system, really the best system in the United States. And really, we are lucky that our legislators have taken the time previously in the past to make it what it is today.